is that it's a pretrial statute. That's not to be confused with 17-5-54, which is the return of property after a trial. So the reason that the 17-530 statute is particularly important is that, and I'll read it for you all. I know you all probably know this, but just so it's in the record. A defendant aggrieved by unlawful search and seizure may move the court for the return of property in the possession of which is not otherwise unlawful. So that means, of course, if it's contraband, other drugs, weapons, or other things that wouldn't ordinarily be subject to being returned, and to suppress as evidence anything obtained on the grounds that the search and seizure without a warrant was illegal, or the search and seizure with a warrant was illegal because the warrant is insufficient on its face, there wasn't probable cause for the issuance of the warrant, or the warrant was illegally executed. The motion shall be in writing, which that one was. State facts showing the search and seizure were unlawful, which it was. The judge shall receive evidence outside the presence of the jury on any issue of fact necessary to determine the motion, and the burden of proving that the search and seizure were unlawful shall be on the state. If the motion is granted, the property shall be restored unless otherwise subject to lawful detention. Lawful detention would be contraband, of course. And it shall not be admissible, mandatory, shall not be admissible in evidence against the movement in any trial. The motion shall be made only before a court with jurisdiction to try the offense. If a criminal accusation is filed or an indictment or special presentment is returned by a grand jury, the motion shall be made only before the court which the accusation, indictment, or special presentment is filed and pending. The last time that we were in court, the court, Mr. Steele, I think we admitted for the court's consideration D1 through 10. Within those documents was the order Judge Newkirk entered. Can I have those, Christine? Do you have those? Do you have those ones? Are they up here? Okay, hold on a second. Okay, hold on. No, that's it. Huh? Thank you. All right. All right, D1 was the accusation that was filed in this case, and that was related to the possession of marijuana charge. D2 was the motion to suppress any and all evidence located from the defendant's home. D3 was the supplemental motion to suppress any and all evidence located from the defendant's home. D4 was the order granting supplemental motion to suppress any and all evidence. And it reads as follows. After hearing testimony, a stipulation of testimony, and argument from the parties on Monday, April the 3rd, 2017, this court hereby grants defendant's supplemental motion to suppress any and all evidence located from the defendant's home. Based on this ruling, the evidence located in defendant Williams' home is subject to the above referenced accusation number, the motion 16
to suppress evidence.
SC 1 and there's 6 fours.
But they are still
specifically
trying to use the evidence.
That just over an ounce of marijuana, it is hereby suppressed and cannot be used in evidence by the prosecution in the trial of Jeffrey Williams, signed by Henry Newkirk on the 10th of April, 2017. There was a motion for reconsideration that was filed or accepted by the clerk's office on the 20th of April of 2017. There was an order, that was D5. D6 is there was an order by Judge Newkirk entered on the 24th of April 2017. The order, it reads as follows. The court having read and considered the state's motion for reconsideration, the same is hereby denied. D7 is a motion for null pros on the same case where Mr. Steele filed a request to have the accusation null pros. D8 is the dismissal for want of prosecution. When the case was called for trial, the state was unable to proceed, and Judge Newkirk has the following reason: the motion to suppress was granted, and he granted the motion to suppress, and that was the 3rd of April 2017. There is a exhibit from our last hearing on the 17th, D9. which is a letter that was written by Mr. Steele to Mr. Charlie Bailey, Esquire, May 17th of 2018. Read the State of Georgia versus Jeffrey Williams, accusation 16 SC 1444444. Dear Mr. Bailey, I hope that all is well with you and your family. I'm writing you to pursuant to my representation of Mr. Jeffrey Williams in the above referenced case. As known, the Honorable Court suppressed all the evidence in the case, was null pros, and prosecution is ceased. Mr. Williams has been attempting to obtain his property that is lawfully his concerning the above referenced case. The City of Atlanta is not releasing the same, as they still have the same marked as evidence, according to Mr. Williams' father. Could you please assist in having the property released to the lawful possession of Mr. Williams or his designee? Please call upon receipt to discuss the above. I look forward to speaking with you soon. Signed, sincerely, Brian Steele. Copies to the two Williams, one being the defendant, one being the senior, his father. D10 is the warrant for search and seizure. And those were the 10 exhibits that were admitted for the court's consideration on the motion on the 17th of November. So the court's concern is that while you all, the state that is, think that Judge Newkirk just specifically excluded the marijuana, he did, but the legal premise behind it would be fruit of the poisonous tree. Anything that was taken in that house at that point in time would be subject to being suppressed. And that's the first thing I'm going to let you all address. The second thing that would be of note is that under 17-5-30, this property was requested to be returned. And the statute's pretty clear, shall not be used in a future criminal prosecution. That is different than the return of property statute during trial 17-5-54. So, yeah, that's why I preface this. I've had an opportunity to take a look at Judge Newkirk's transcript, which will also be included for purpose of the record, is the next court exhibit from the 3rd of April of 2017. So with that, Ms. Love, what say you and your colleagues?
Yes, Your Honor. First of all, Your Honor, understanding the court's review of the transcript, I want to point out that in ruling on evidence that pertained to the possession of marijuana charge that Mr. Williams faced in that indictment, the court specifically, during the course of the proceedings, clarified during an exchange with the prosecutor, he is only seeking to suppress the marijuana.
I agree with you that, but the legal premise would still hold on anything that was taken in that home by a search warrant. You had an arrest warrant issue, and then you had a search warrant issue. So if Mr. Steele challenged the arrest to begin with, the warrant or copies of the arrest warrant and the warrant under Baez, which he versus the state, which is a 206 Georgia 552, which he cited at that point in time. That would make it so that anything else in the house that was taken would have been subject to being suppressed. Mr. Steele amended his motion. He asked for everything. Okay, all right, Mr. Steele, sorry about that. Okay, so I do have the transcript from April the 3rd of 2017 with, and I've labeled it as the court's next exhibit in order. Court's 2 for purposes of this motion.
So, Your Honor, if I may go backwards for a second, if that's okay, I'd like to just first discuss and take care of State versus Alford. It's ALFORD, and it's 347 Georgia Appeal 208. It's a 2018 case that the Honorable Prosecutor has cited to this court. It's in Division 3 that the prosecution is relying upon, and it is wholly inapposite to what we're dealing with here. What we're dealing with here in Court's Exhibit number 2, which is the transcript from April 3, 2017, has nothing to do with what happened in Alford. In Alford, Mr. Alford is a passenger in a vehicle. The car gets stopped. Law enforcement officers see open containers and they smell marijuana as they approach the car. The officers then ask Mr. Alford, is that your backpack at your feet? And the answer is yes, and there's contraband, there's drugs inside the backpack. Mr. Alford is arrested and he's prosecuted for that. The Honorable Trial Court had a pretrial motion to suppress, and the state of Georgia was on notice that Mr. Alford, just like the Honorable Mr. Williams, challenged the actual arrest. And the state of Georgia did not bring in a certified copy of a county ordinance saying that you can't have a person can't have an open container in a car. Because of that, the trial court granted the motion to suppress. The state of Georgia appealed. What happened in the Court of Appeals was as follows. The Court of Appeals said that's exactly right. Without introducing the certified copy of the county ordinance, there was no arrest for that purpose. But what the court then went on to hold is, however, when law enforcement officers lawfully walked up to the car, they smelled marijuana. And the odor of marijuana in the state of Georgia is a reason, probable cause, to search the car under the automobile exception. And because the automobile exception kicked in, it didn't matter that there was no certified copy of the county ordinance, and the Honorable Court of Appeals of Georgia found that the odor of marijuana was sufficient probable cause. The police then could search the car under the automobile exception. The backpack then, therefore, should be searched. The contraband inside the backpack should not. In Court's Exhibit number 2, so Alford is like a waste, respectful, I don't mean to be rude. It is just not even close to what we have here.
Can I hijack for just a second, Mr. Steele?
Of course.
We're going backwards. We should be going forwards. That, I agree with you with your, at the status of your hearing in front of Judge Newkirk, you know, the issues involving the search warrant, the arrest warrant, the search warrant, and these issues would have been, it's a snapshot in time. Since you filed another motion to suppress, the state now is willing to at least present forth evidence to show that the arrest warrant, the search warrant, and the seizure of these particular items, that there is a basis, because we've gone forward and it's another case. So can you address that for me? Because I don't believe that I can I have to kind of look at it from my foxhole, because this evidence is related to, you filed a motion to suppress in this case. So I can't rely totally upon what Judge Newkirk has indicated. And also, this case was never appealed, so there's no really appellate ruling on this issue. So I would argue it's ripe to consider again.
I would respectfully disagree. I wish I could do that in every case that I don't win, that I can come in and do a second bite at the apple. This is the exact
But it's a
issue.
different case.
No, it's so then the state can just, I win a motion to suppress.
No, it's a different. Okay, it's a different case. That was just a possession of marijuana case. This is a RICO case, and this is they're arguing at this point in time, since you filed another motion to suppress, that we look at probable cause and the other things from the vantage point of 2022.
Your Honor, I filed a motion to suppress based upon the law of the case. It's a final order. It was not appealed by the state of Georgia. It is a final order. It doesn't matter. It didn't go up to the appellate court. And it is the same issue that's already been litigated between the same parties, Mr. Williams and the state of Georgia. They're still the state of Georgia. It is race. Judge Newkirk considered the following. My motions, which are in front of the court, the original motion and the supplemental motion, challenges everything that was taken from Mr. Williams' home.
Your motion to suppress is D2, and your supplemental motion is D3.
And it challenges everything that was done because the police unlawfully, as found by the Honorable Judge Newkirk, entered Mr. Williams' home. So what happens at our hearing, specifically
inside the house,
at transcript,
but the prosecutors are only trying to say it was
Page
only
18.
for the marijuana they found in the house. How
this is
could
on my
that be?
cross-examination of the lead officer.
They just try to do anything, man.
I'm with you.
Specifically, starting at page line 5, line 3. The answer is, yes, sir, I do believe there was an arrest warrant. I interrupted. I didn't mean to interrupt, but I interrupted. I said, I didn't mean to cut you off. The answer continues. That is what the warrant was for. Yes, sir. Then my question is, and that warrant was from a long time before. If you know, and if you don't know, we can get the information through someone else. Answer, I don't know the exact actual. I then asked, were you aware the warrant or the case was eventually dismissed? Answer, I'm not certain, sir. My question, so law enforcement officers do not have a search warrant, though at that time, this is simply an arrest warrant. Answer, correct. On page 33, which is what the state is trying to hijack, to use your word, Your Honor, this motions transcript and wrongly mislead the parties on what it says. The trial court, Honorable Judge Newkirk, on line 14, states, all right, no other evidence, brief argument. The Honorable Mr. Bailey, then District Attorney in Fulton County, said, Your Honor, the defendant has filed this motion through his attorney, Mr. Steele, challenging, while seeking to suppress evidence in this case that was collected from Mr. Williams' home at the time. The basis of this motion is, and the Honorable Court interrupts, the only thing he's challenging is marijuana, which is what the state seeks. Mr. Bailey says on line 23, right. The basis of the motion, thank you, Judge, the basis of this motion is essentially that, in the motion filed by the defense, that law enforcement officers did not have the right to enter the home, did not have the right to enter the home to effect the warrant. Going down to line 3, it's on page 34, continuing. Mr. Bailey, the district attorney, on page 3.
Interrupt you a second.
Yeah, of course.
IT is about to create a new secure Zoom link, but it's only for the attorneys. You're not to share the link. You understand me? Good? All right, thanks. Okay. I'm sorry. Continue.
That's okay.
I apologize.
On page 3, 34, Your Honor, of Court's Exhibit 2, line 3. This is Mr. Bailey, the district attorney at that time, or senior assistant district attorney. On page 3 of the motion, it states, Mr. Williams was arrested on a DeKalb County warrant. However, law enforcement officers unlawfully entered and searched Mr. Williams' home, even though they were supposedly armed with an arrest warrant, and there was no need to search or even enter Mr. Williams' home in an effort to serve this alleged arrest warrant, as there was no lawful reason to force entry in Mr. Williams' home. Then there are two parts here, and that's the long and short of it. Did they, meaning police, have the right to effect the arrest warrant, and what did they see once they got inside that would rise to probable cause. Then skipping, Your Honor, to line 21, same page 34, this is Mr. Bailey again. Normally, officers can't just walk into folks' homes. That is well established, but there is a carve-out for affecting. Officers have reasonable belief the individuals inside. So it is not this way the state is saying that it's only somehow marijuana. I challenge the entry into Mr. Williams' home. When law enforcement went into the home, they allegedly found marijuana, guns, other contraband, and that's when eventually the seizure of all of Mr. Williams' electronic devices that I've challenged, that should have been returned, I've challenged, cannot be used in this case. On page 35, the district attorney said at the end of line 1, Your Honor, or it's the middle of line 1, an arrest warrant found on probable cause implicitly carries with it the limited authority to enter a dwelling in which a suspect lives when there is reason to believe he is within. The state is saying the entry into Mr. Williams' home was unlawful. He has his constitutional rights violated. He's a victim. The court should say respectfully, no way, this would litigate it. On page 36, the district attorney continues. It's on line 10, Your Honor, and the parties. Now, were the facts that they knocked and he came to the door, and they, meaning the police, Your Honor, detained him, meaning Mr. Williams, then Mr. Steele would be completely correct, and they could not enter the home. They affected the arrest warrant. Then skipping to line 19, Your Honor, page 36. So they have all clear lawful authority, talking about the police, to go in to affect the arrest warrant. And then we get to the second point, and it is in the same Wall case. Wall is W-A-L-L. It states on the last page, once inside the apartment, the law enforcement officers had the authority to seize marijuana that was in plain view. I challenge that law enforcement had no right to go into Mr. Williams' abode. And then the prosecutor on page 36, line 25, concludes, that is exactly what we have in this case. Once law enforcement is inside, they see marijuana on the coffee table in the master bedroom suite, and additionally marijuana on the nightstand in the master bedroom, and Detective Gaither further testified there were guns located in the living room.